So here we're going to look at the rule in Sharp versus Dawes. The rule in Sharp versus Dawes. Going to look at the essentials of a valid meeting. The essentials of a valid meeting in a company. The essentials of a valid meeting in a company. Then we will look at the types of meetings in a company, the types of meetings in a company, the types of meetings in a company. Then we will look at resolutions in a company meeting, resolutions in a company meeting. Here, basically, we look at what is an ordinary resolution, and a special resolution. What is an ordinary resolution and a special resolution? What is an ordinary resolution and a special resolution? What is an ordinary resolution and a special resolution? So that is basically what we are going to look at under this particular topic of company meetings, So, so a company will basically have to operate with regard to basically people having to come together, deliberate on matters concerning the company, how it is supposed to be run. So it will not just be there. So there must be at least be some form of assembly of people or the key stakeholders in the company to be able to deliberate on matters concerning the company, on how the company is actually supposed to be run. So in this case, for a company, basically there will be meetings that will actually happen there. For example, we can have directors having to meet to discuss matters concerning the management of the company. We'll have, for example, the shareholders of the company having to meet to discuss or basically approve certain matters concerning the company. So in short, what we mean is that a company will operate in this way, that all the matters concerning the company, before anything actually happens in the company, there must be at least some form of meeting with regard to the key stakeholders of the company. So that's why we are saying that, for example, at these particular meetings, there'll be the passing or approval of what we call ordinary resolutions and what we call special resolutions. So what we mean by resolution is simply basically decisions taken or basically agreed upon at a general meeting or basically at a meeting of a company. So they can either be the passing of an ordinary resolution, or they can either be the passing of a special resolution. So several meetings can actually happen in a company. We've said, for example, we are talking about members of the company having to meet. So you can have what we call, like, for example, general meetings. We can have an annual general meeting, which I think I've previously mentioned. We can have directors meeting in the company. So we can have a board of directors meeting. We can have creditors. So the other key stakeholders of the company, they can actually be able to meet within the company and discuss matters concerning the company. So they are the key stakeholders of the company. So we can have a creditors meeting in a company. We can have a creditors meeting in a company. So what we mean by company meeting is simply just an assembly of the key stakeholders of the company to deliberate or basically discuss matters concerning the company, more so as to how the company is actually supposed to be run, or basically how it's supposed to carry out its activities. So the company won't just be there. For it to be able to operate or basically to run, basically there must be some form of basically meetings that are going basically to happen in the company on basically maybe management matters. So anything to do with the company will actually be discussed at a company meeting. So here there's usually a very famous rule. So it is known as the rule in Sharp versus Dawes. And as the norm, or basically as what you've discovered since we started learning about company law, any major rule we come across, it has exceptions. So this particular rule also has exceptions. So we look at also the exceptions to this particular rule we are calling the rule in Sharp versus Dawiz. The rule in Sharp versus Dawiz. The rule in Sharp versus Dawiz. So what this particular rule actually states, it states that for a proper meeting to be convened in a company, it must be held by at least 2 persons. So for a proper meeting to be convened in a company, for a proper meeting, it states, for a proper meeting to be convened in a company, it must be held by at least 2 persons. It must be held by at least 2 persons. So what they mean by this is that for any meeting, or basically for it to be concluded that there was a meeting in a company, there must be an assembly of at least 2 persons. If basically any matter is decided upon by only 1 person, it simply means that that was not actually a meeting to be able to approve or deliberate a matter concerning the company. So it simply states, just the way the teacher said, for a proper meeting to be convened in a company, it must be held by at least 2 persons. So it simply means that it must be 2 or 3 or maybe 4 going up like that, but not actually one person. So if you look at basically circumstances surrounding some of the operations of the company, you realize that some of the resolutions of the company will simply just be approved by a sole person, 1 person. So there is no need to call for a meeting of at least 2 persons for those particular matters to be decided upon in a company. That's why we have what we call exceptions. So because what I'm telling you, the key or the most important thing that actually happens at a company meeting is approving or passing of resolutions. So these are decisions taken upon at the meetings of the company. So it can either be an ordinary or a special resolution. So what we mean by this, that this particular rule has exceptions. You might find under certain circumstances, certain resolutions of the company, it is not a must that they be approved by at least 2 persons. 1 person can actually be able to approve such kind of matters or decisions. In such a case, we simply conclude that in that case, the meeting was held by a sole person. It was actually basically held by 1 person. So in this case, what normally comes, basically what most obviously some students normally ask, how can 1 person basically form a meeting? So that's the question you're asking yourself. Why is the teacher saying that in this case, 1 person has actually been able to form a meeting? What I've told you, at company meetings, basically what happens there is passing of resolutions. And what this particular rule states, those resolutions can only actually be passed by at least 2 persons. But the teacher has said under exceptional circumstances, certain matters can only basically be approved, or basically if you look at circumstances surrounding that company, a certain matter will only be approved by 1 person. It is normally concluded that that person was actually able to form a meeting and passed a resolution. Because I've told you at company meetings, what happens? They pass resolutions. So in that case, it simply means that that person basically upon himself was actually able to pass the resolution. And therefore it is concluded the meeting in such a case was basically held by a sole person and he was actually able to pass a resolution. What are these exceptions? Number 1, for example, in the case of a private company that is formed by a sole person. Remember, the teacher said when we are looking at nature and classification of companies, that a private company, it is a type of a company that is normally formed by 1 person. It can be formed by 1 person up to 50 persons. So what we mean by, in this case, this person we are calling, or this friend of ours we are calling Matthew. Matthew has actually been able to form his own private company. In this his own private company, he is the sole member and is actually basically the sole shareholder and is actually basically the sole director. In this case, if Matthew is to pass a resolution, will Matthew go out looking for another member, yet that particular other person is not actually a member in the company? No, Matthew will simply approve all the matters concerning the company, especially what to do with regard to what we call board of directors resolutions. So Matthew will be the sole director. Matthew will be the sole member of the company. Matthew will be the sole shareholder of the company. All the resolutions in that particular company will basically be approved by Matthew. In such a case, we simply basically conclude the meeting was held by the sole shareholder of the company, and he was actually able to pass the resolution. So number one exception, in a private company with a sole shareholder who is the sole director of the company, the board of directors meeting in such a case will actually be formed by that sole person, or basically sole shareholder, who we are calling Matthew. That is an exception to this particular rule that was stated in Sharp versus Dawes, whereby they were saying it is a must, it should actually be held by two persons. But that is a special circumstance whereby now the resolution in such a case will simply be passed by a sole person. So the teacher has said, exception number one, in a private company that is formed by a sole person who is basically the sole shareholder and director, the board of directors meeting in such a company will be formed by one person. I've already explained how basically that particular one person can actually be able to form a meeting, simply because he'll be able to decide upon all the matters concerning the board of directors meeting in such a company. For example, in this case, if the bank asks for a resolution or a board resolution that basically approves the opening of a bank account, the only person who will actually be able to conclude that a meeting was actually held is only Matthew, and is the only one who signed that particular resolution. So in such a case, it simply means that Matthew was actually able to form a meeting and he passed a resolution to basically open a bank account for that particular company. That is exception number one. Exception number two. A meeting convened by the order of the court. If the attendance is actually only one person, that person will actually it will be concluded that that particular one person has actually been able to form a quorum. So sometimes in the company, maybe some of the members are basically absconding the meetings. So they want to pass a particular resolution, but the meeting is not actually being called, or the meeting is not actually being held. So maybe one of the members goes to the court and he basically concludes that, or basically states to the court that this company has not actually been able to hold an annual general meeting for the last 4 years. It has not actually been happening, and it is mandatory under the law that the company holds an AGM each and every year. So in such a case, if that particular member goes to the court and the court gives out an order, the company should actually be able to call for a meeting, and the other members actually abscond the meeting, it will be concluded that that particular one person was actually able to form a quorum to discuss and basically approve the resolutions of the company. So number two, the teacher is saying a meeting convened by the order of the court. If the attendance is actually only one person or one member, that one member will actually be able to form a quorum. So a meeting convened by the order of the court, if the attendance is a sole person, basically one member, the one member will actually be able to form a quorum. Number three, exception to this particular rule we are talking about, it is also a meeting convened by the order of the registrar of companies. So in such a meeting, if only one person attends, he will be able to form a quorum and of course pass the resolutions of the company. So number two, it was the order of the court. Number three, it is the order of the registrar of companies. So a meeting convened by the order of the registrar of companies. In such a case, if one member actually attends the meeting, he will actually be able to form a quorum. That is another exception. Exception number four. If in a company we have only one creditor, and in that company, the company wants to hold what we call a creditors meeting, that one creditor will actually be able to form a quorum and decide upon matters concerning creditors in that company. So in such a case, if they ask for any matters concerning creditors, he will be the only one who will be able to write down or basically approve all the matters concerning creditors and forward to the company, because he's the only sole creditor. But that is actually a very unique case. So in such a case, if we have a company that has only one creditor, if the company is to hold what we call a creditors meeting, that creditor is the only one who will be able to form a quorum, and therefore will likely be able to pass resolutions concerning the creditors in that particular company. So that is actually an exception to this particular rule, whereby they are saying it must be two. So if the company has only one creditor, it simply means that that sole creditor will be the only one who will be able to form a quorum. So in a company where we have one creditor or a sole creditor, the sole creditor will form a quorum in case of a creditors meeting. Creditors meeting is actually very key there. So in a company where we have a sole creditor, the sole creditor will form a quorum for a creditors meeting in the company, for a creditors meeting in the company, for a creditors meeting in the company. So repeat number two. Exception number two is said, a meeting convened by the order of the court. If the meeting is attended by one person or one member, the one member forms a quorum. If a meeting is convened by the order of the courts, order kutoka kwa koti, and in that meeting only one person attends, it will be concluded that that one person has been able to form a quorum to pass the company resolutions. So that is number two that we had actually mentioned. So I can see Purity was asking, repeat number two. So the teacher has already mentioned number four. He has talked about a creditors meeting that is attended by a sole, that is based in a company that whereby we have only a sole creditor. So that sole creditor will actually be able to form a quorum. So that is actually an exception to this particular rule. Exception number five. Exception number five. If there is what we call a class meeting, if there's what we call a class meeting, in that class meeting, if that class of shares has only one shareholder. What do you mean by a class meeting? Let me explain first. What do you mean by a class meeting? Remember when we were talking about shares, we talked about several classes of shares. We said we can have ordinary shares, we can have preference shares. If you can remember very well, founders shares, employees shares. So if you can remember very well what the teacher was mentioning about classes of shares that we can have in a company, simply types of shares we can have in a company. We can have ordinary shares, we can have preference shares, we can have redeemable preference shares, we can have founders shares, we can have members shares. So what we mean by a class of shares, in this case, for example, if a company has only one shareholder under redeemable preference shares, only one shareholder has actually been able to acquire redeemable preference shares. And in such a case, in the company, there is supposed to be held what we call a class meeting. What do you mean by a class meeting? Is simply that, for example, all the ordinary shareholders are supposed to meet as a class. Or basically, all the preference shareholders are supposed to meet as a class in the company and discuss matters concerning them as preference shareholders. If in such a case, the preference shareholders in that particular company is only one person, there is only one person who is holding preference shares in the company. If there's supposed to be a class meeting, that class meeting will only be held by that sole shareholder who is holding the preference shares. So number five, a class meeting in a company where the shares in that class of shares, the shares in that class, you can say the shares in that class are held by a sole shareholder. A class meeting in a company where the shares in the class are held by a sole shareholder or member, a sole shareholder or member. So the key thing there is for you to be able to understand what is a class meeting. So a class meeting is simply whereby you are saying the members of a class of shares are actually able to meet and actually discuss matters concerning them as members of that class of shares. So in this case, I've said, for example, in a company, if we have only one person holding the ordinary shares, if that class of shares is to deliberate matters concerning ordinary shareholders in that company, since these shares are actually held by a sole person, that person is the only one who will be able to deliberate and basically decide upon matters concerning that particular class of shares. So it will be concluded that that particular shareholder was actually able to form a quorum and basically approve a resolution concerning a class meeting for that particular class of shares, So that is exception number five. That is exception number five. So number six is, for example, at a convened meeting. What do you mean by at a convened meeting? And of course, there's no quorum. So in such a case, if there's no quorum, the meeting is actually postponed to maybe next week, the same time, or maybe the other week. And of course, at that particular postponed meeting, only one person attends. That one person can actually be able to form a quorum and pass resolutions. You know what can actually happen in the company is that, for example, they could be calling for a meeting. And of course, kuna wale vichwa ngumu, wale shareholders vichwa ngumu. So they gang up together and say, we want to defeat the quorum, so we won't attend the meeting. So they do it the first time. And of course, they are still actually ganging up together. So it is quite obvious, most probably, if you basically postpone to the same time next week, they won't attend. So what in this case, basically the law tries to protect for such, or basically safeguard against such, is that at a postponed meeting, if at that particular postponed meeting, that one person who is actually able to attend can be able to pass a resolution, it will be concluded that he has actually been able to form a quorum. So number 6, what the teacher is saying, at a postponed meeting of a company that is actually attended by a sole member, the sole member will form a quorum to pass company resolutions. So those who are basically absconding deliberately, so to defeat quorum, so they'll be caught there. So they have no option but basically to attend at that particular postponed meeting. So at a postponed meeting where the quorum is a sole person or a sole member, the sole member can actually be able to pass resolutions for the company, Those are the exceptions to this particular rule in Sharp versus Dawes. It is very common in the exam. High chances they can test it. It is very common in the exam. Exceptions to the rule in Sharp versus Dawes, or they could simply basically start with the Roman 1. State the rule in Sharp versus Dawes. Roman 2. What are the exceptions to the rule in 1 above? It is very common in the exam. So essentials of a valid meeting in a company. What are the essentials of a valid meeting in a company? Or how can we actually be able to conclude that there was actually a very valid meeting that was actually held in a company? How can we actually be able to conclude there was a valid meeting that was actually held in a company? So we can look at the essentials or key characteristics that should actually be present for it to be concluded there was actually a proper convened meeting in a company. Essentials of a valid meeting in a company. So number 1, the meeting must be convened by the proper authority. The meeting must be convened by the proper authority. Then number 2, the meeting must be convened by a notice. It should be convened by a notice. The meeting should be convened by a notice. The meeting should be convened by a notice. There should be what we call a proper quorum. Then the next thing, there should be what we call a proper person as the chair. A proper person as the chair. Then the last one, number 5. Minutes should be maintained. 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 So those are the essentials. Those are the essentials of a valid meeting in a company. Those are the essentials of a valid meeting in a company. The essentials of a valid meeting in a company. So those are the essentials of a valid meeting in a company. So we are saying that for it to be concluded there was a proper meeting in a company, there should be it should be convened by the proper authority. So proper authority should have convened the meeting. Number two, there should be a notice. So you don't just wake up and just say there is a meeting. So you're going to hold a meeting. There should be a notice that should be sent out. And then before the meeting is actually held, it should be ascertained that there's actually quorum. So to be able to pass maybe a special resolution or an ordinary resolution. Then in any meeting, you'll hear people saying, who is the chair, leaders or guiders. So I think most of the meetings that basically are discussing serious matters, you'll basically expect there's a person as a chairman or as the chair lady. Even if it is that committee or basically wedding, meeting for a wedding, meeting concerning basically burial arrangements. So there's obviously a person as a chairman to be able to guide the meeting or basically direct the meeting. So the same case in a company. For any meeting, there should actually be a person known as a chair. Then minutes, most of the meetings you'll hear people saying, who is maintaining the minutes? Who is keeping the minutes? Even in that basically meeting for a wedding. So who is maintaining the minutes? And the minutes are actually normally shared later on. So if it is a chairman meeting, so who is maintaining the minutes? Who is the chair lady of this particular chairman? Who is the chairman of this particular chairman? So there should actually be maintenance of minutes, the same case in a company. So that meeting should actually ensure that the minutes are actually being maintained. So what you need to understand is that with regards to the authority to be able to convene a meeting, so the proper authority to be able to convene a meeting in a company, so this is actually very key, you need to understand or basically be able to know. The proper authority to convene a meeting in a company is normally the board of directors of the company. So they're the ones who will basically be able to approve or pass a resolution at the board level that basically there is supposed to be a meeting in a company. So they'll be able to craft that notice and be able to ensure the company secretary has actually been able to send it out. So the proper authority to convene a meeting in a company is usually the board of directors or the director of the company. So they clearly decide at what time or at what particular point the meeting is actually supposed to be held in the company. Then you might find that maybe these particular directors have failed to convene a meeting, because remember, these directors have just actually been appointed by shareholders to run the company on their behalf. So they are insiders who actually understand what is happening in the company and they know what is the right time to call for a meeting. But if things are not actually going well, and of course directors are not actually able to call for a meeting, the members can actually be able to take this particular matter in their hand, and of course they can petition the court or ask the courts to be able to call for a meeting in the company. That's what we are saying there under the exceptions, a meeting convened by the order of the court. The order will come in this way, such that, for example, if the board of directors have failed to call for the meeting, you as a member of the company, you have a right to basically go to the court and basically give you your reasons as to why you think the meeting is supposed to be held in the company, yet the directors have not actually been able to call for the meeting. Maybe the company is not actually going on well, basically it's not running its activities well. And you as a key stakeholder, or basically as the owner of the company, as a shareholder, you have that right as a member. So you can go to the court, petition the court, and of course give reasons as to why you want the meeting to be held. Yet directors have not actually been able to call for the meeting. So you can petition the court, and the court basically will give out an order that the company is supposed to hold a meeting. So the mandate lies on the directors or the board of directors, but if they have failed, basically you as a member, you can actually be able to take a step, maybe go to the court, or basically convince the other members to go to the court, and of course the court will give out what we call a court order for a meeting to be held in the company. So that is basically what you need to be able to know with regard to the proper authority to convene a meeting in a company. So you've said the meeting should actually be convened by a notice or a proper notice. So here, most obviously, maybe what the examiner could test you in this particular area, they could ask, what are the contents of a notice that is issued out by the company, or who are the parties entitled to a notice of a meeting in a company? Who are the parties entitled to a notice of a meeting in a company? So the parties entitled to a notice of a meeting in a company, for example, most obviously are the members of the company. So they have to get a notice of a meeting in a company. Another key party who is actually very important, and you know him, or you know this particular person, it is actually the auditor of the company. So he has a right to notices of meeting in a company. Other parties who are actually also very important in the company are directors. So they have a right to be able to get notices of meetings in a company. So, or we can have basically, for example, like a legal representative to a deceased member of the company. So you've talked about members of the company, auditors, they have a right to get a notice. We have directors, they have to get a notice. So you can have a legal representative, or basically an administrator of an estate of a deceased member of the company. So those are the parties who have a right to attend, or basically not basically to attend, to get a notice of a meeting of a company. So what will be the contents in a notice of a meeting? So most obviously what you will get there, contents of the notice of a meeting, what you'll get there is the place of the meeting. Place of the meeting should actually be clearly be indicated there. Place of the meeting, place of the meeting. What will actually also be contained there in the notice of the meeting is basically the dates and time of the meeting, date and time of the meeting, date and time of the meeting. Also, you'll actually be able to get there what we call the agenda of the meeting. What are you going to discuss? Are you going just to take tea and mandazi, or basically you're going to discuss serious matters concerning the company, or are you just going to do what we call moshene there, or basically you're going to discuss serious matters? So it should actually clearly be indicated what is the agenda that will actually basically be taking place in the meeting. So that is a key content to a notice of a meeting. Another one is the authority convening the meeting. You'll be able to tell it from the notice. So basically, of course, maybe it will be signed by the chairman of the board down there under the notice, so that people can actually be able to know who is convening the meeting. So maybe just someone who, from anywhere, who's just put a notice, yet there's no any meeting that is supposed to happen in the company. So it will clearly indicate the authority convening the meeting. Maybe it will be signed by the chairman of the board and also the company secretary. So people can actually be able to understand who is actually calling for this particular meeting in the company. So those will be parts of the contents of a notice of a meeting of a company. Such a simple question can actually be tested. So you just need to be very alert and actually be able to understand what will be contained in the notice. So they could ask that one, we just discussed that who are the people entitled to a notice of a meeting of a company. So that is what you need to be able to know under what you are calling notices of meeting, notices of meeting. So quorum, so there must be a proper quorum. So what we mean by a quorum is basically the specific number of people actually qualified to be able to attend and actually approve a resolution at a company meeting. So they'll be able to form what we call a quorum. So those, basically that's what we mean by a quorum. It is the specific number of qualified persons who are supposed to attend. So a quorum is the specific number of people who are supposed to attend and approve a resolution at a company meeting. So those who are supposed to, specific number of people are supposed to attend, the specific number of people are supposed to attend and approve a resolution at a company meeting, and approve a resolution at a company meeting. So I can see Nemo is asking who issues the notice. So we've already said that a properly convened meeting in a company will actually be convened by the board of directors. So those who issue the notice is normally the board of directors. And of course, the company secretary will, there's a topic number 9 that we are going to look at. It is known as the company secretary. We'll see the important role of a company secretary in a company. Part of the mandate of the company secretary is it is normally to send out notices of meetings in a company. So that's why I'm saying that particular notice will be signed most of the time by the chairman of the board of directors, and of course the chairman of the board of directors, and of course also the company secretary, and of course also the company secretary. So those are the persons basically who will be able to issue the notice of the company meeting. So we are saying the board of directors plays a key role, and of course the company secretary. And most obviously in several companies, the company secretary is normally part of the board of directors, to be able to advise the board of directors on several matters concerning operations of the company or how meetings are supposed to be convened in the company. So the person who normally convenes is the board of directors. Just say the board of directors there. So the company secretary is part of the board of directors. So that is what we are talking about, a quorum. So that is what we are talking about, a quorum. That is what we're talking about, a quorum. So there's this one, proper person as the chair, but before we look at this one, maybe I can share a particular question which I have an interest in, which you need to know. Let me just share this particular question. Give me like 2 minutes. So there's this one. So this was the last sitting. So in May 2021. So this is what they tested. Question number 7C. They tested this. The case of Sharp versus Dawies indicates that one person cannot constitute a meeting. So that's what the case of Sharp versus Dawies actually indicates, that a meeting is actually supposed to be held by only two persons. Explain 4 exceptions to this particular rule. Explain 4 exceptions to this particular rule. So this was actually tested in the last sitting, this that they just did in May. So what are the chances? What are the chances they are going to repeat this question in this coming sitting? What are the chances? What do you think are the chances they'll repeat this particular question about Sharp versus Dawies? What are the chances they'll actually be able to repeat? So that's why I was telling you this one is actually very common. If you check the other previous past papers, they have actually tested it like almost 4 times or 3 times. But what are the chances? It was tested in the last sitting. What are the chances they are going to repeat it in the next sitting? The chances are quite minimal. The chances are quite minimal. So they might not test it. So maybe they might dwell on another case law, a major case law that the teacher talked about. Because in this one, they have tested Sharp versus Dawies. So most probably in the next one, they could test Trevor versus Whitworth and the exceptions. Because I've told you, this is actually one of the major case laws in company law, Sharp versus Dawies. So they like playing around with them. So most probably in this sitting, they have tested Sharp versus Dawies. So maybe the next one, they could test Trevor versus Whitworth, or maybe they could dwell on another one like Solomon versus Solomon and Company Limited and the exceptions. Because as I've told you, the major case laws in company law, they are countable. They're like 5 or 6 of them. They have exceptions. So Sharp versus Dawies, it has exceptions. Trevor versus Whitworth, it has exceptions. Royal British Bank versus Taquant, it has exceptions. Solomon versus Solomon and Company Limited, it has exceptions. Force versus Habutil, it has exceptions. And actually, this is actually the last major case law we are going to come across. There's no any other major case law moving forward up to the last topic. So this is the major one that they like testing. So those ones, they like testing them in the exam because they are major case laws and all of them have exceptions. So most probably they could ask you state it and simply state the exceptions. So if you are better off if you know all of them, then you are quite safe. So that's what I was asking. If they tested this one in this sitting, what are the chances they'll repeat in the next sitting? The chances are quite minimal. Maybe what they'll test in company meetings is something different. They could actually be able to test something about maybe the duties and the powers of the chairman. And actually, there's a question I wanted us to look at. I'm just going to show you that has more to do with the chairman of a meeting. So what are the chances they might actually repeat this one? So they are quite minimal. But of course, you know the answers. I don't have to give you again. So I've really repeated them when we started this particular topic. So you know them, you know the answers. A meeting convened by the order of the courts. A meeting convened by the order of the registrar. In a private company with a sole shareholder and who is the sole director, the board of directors meeting in such a company, basically, it will be held by a sole director. A creditors meeting in a company whereby you have only one creditor. A class meeting in a company where the shares in that class of shares are held by a sole shareholder. At a postponed meeting, where the attendance or basically the quorum is one person. So such a person will likely be able to form a quorum for the meeting. Will actually be able to form a quorum for the meeting. So maybe let's look at another one. Let me just show you another one.
Okay, Mwalimu.
Yes.
We can check November 2015 question 4.
November 2015 question number?
4A.
4A. Let me just go to it. November 2015 question number 4A. November 2015 question number 4A. Oh yeah, in fact, you've just gotten the question that I was talking about. Just I told you they can test such simple things. You can see that one, the one that has just been highlighted by our friend there. Outline the rules governing the following: entitlement to notice of a meeting. So 4 contents of a notice of a meeting. So I think that one we've just covered a while ago. And I think we've said who are the parties entitled to a notice of a meeting. So I think this one was how many marks? It was, you can see 2 marks. And of course, on contents, they tested, they gave 4 marks. So there's someone talking about a question about cutting of a melon. So this one was actually in the last sitting. So I think I'll give the answer to it, but not in this particular class, but I'll just give you the answer. There's a question I'm interested in. It's about chairman of a meeting, powers and duties of a chairman of a meeting, which I wanted to show you. So that is the last thing we are going to look at, and we go to sleep. It is a very important question because I know if they test that one and you have no clue, you'll be knocked off, and probably it can even be 10 marks.
Mwalimu, that one for content, not content, entitlement.
You're saying?
That one for entitlement. What exactly are they asking? Like, what are we supposed to answer?
What are they asking?
What's the mean?
Okay, maybe I can go back to the question. Let me go back to the question. Outline the rules governing the following: entitlement to notice of a meeting. Entitlement to notice of a meeting. So they're simply asking the parties who are actually entitled to a notice of a meeting of a company. So what you need to be able to do there is just that the persons who will be entitled to a notice of a meeting of a company will be members of a company, comma, you can say comma, members of a company, comma, and then you say directors of a company, comma, auditors of a company, and legal representatives of deceased members, or basically administrators of estates of a deceased member. So this is simply a person who was a member of a company, but basically his shares are being administered. So they're basically going to share among the next of kins, or maybe those are supposed to inherit the share. So they'll be taken over by the administrator of the estate. So the one who's supposed to basically distribute the assets of that deceased member. So they want basically to be able to state and clearly indicate who will be entitled to a notice of a meeting of a company. So the persons who will be entitled to a notice of a meeting of a company will be the members of a company, comma, auditors of a company, comma, directors of a company, and basically also legal representatives of a deceased member of a company. Number 2, I think that one is quite direct. So that's what they need you to be able to indicate in terms of entitlement to notice. Who is entitled to a notice of a meeting of a company? So if you're able to bring out who are the persons entitled to a notice of a meeting of a company, you will score your clean 2 marks. You will score your clean 2 marks. So then there, the contents, you just need to indicate the contents of a notice of a meeting a company include. So we can say, for example, A. So we've said that it will basically have the date and time of the meeting, The agenda of the meeting should actually also be included there. The agenda of the meeting will actually also be included there. It will be signed, or basically you'll see the signature of the person basically convening that particular meeting. So you'll be able to see it from that particular notice. So place of the meeting, where will this particular meeting actually be held? The agendas, so the agenda should actually be there. The agenda should actually be there. So I hope I'm clear on that. I hope I'm clear on that.
Yes, thank you.
So let me just stress this particular question. Let me just stress this particular question on the chairman. I was almost there. It is around November 2018 there, November or May 2018. So I can't remember the exact sitting. I think it's May 2018 or November 2018, one of the two sittings. If you've gotten it also, you can be able to tell us. It's May 2018 or November 2018 about the chairman of a meeting. The powers and duties of a chairman of a meeting. Yeah, I've gotten it. Is November 2018, question number 7A. So let me just show you. It's November 2018, question number 7A. I've just gotten it. So that's one. I hope you can be able to see. It says, in the context of company, in the context, sorry, it's not that one. Question number 7A. With the reference to the case of National Dwelling Society versus Sykes, enumerate 5 duties and 5 powers of the chairman of a general meeting of a company. So that is the most common thing they'll be able to test about a chairman of a meeting. So they'll basically look at, they could ask what are the duties, or they could ask what are the powers of the chairman of a meeting. So the duties are basically those ones, basically, for example, outlined as maybe under the statute or under the common law. And then, of course, also we have some powers that the chairman will have. So in several meetings, you'll see the chairman has certain powers. For example, he can actually be able to eject a person who is basically causing disturbance. So he'll bring the meeting to an order. If people are making noise, you'll see maybe the chairman is saying, can we have some order? For example, if there's a person who wants to bring out a point, he'll basically be able to maybe give him a chance to be able to maybe iron out his issues. So those are some of the powers you can actually be able to see on a chairman in each and every meeting. Then, of course, also this chairman in any meeting, he'll actually be able to have what we call the power to adjourn the meeting. So he can actually be able to basically declare that the meeting has been postponed up to maybe next week or maybe a particular date in future. But what I want us to capture first are what are the duties of a chairman of a meeting. So you can actually be able to summarize them somewhere. You can actually be able to summarize them somewhere. The duties of a chairman of a meeting. The duties of a chairman of a meeting. The duties of a chairman of a meeting. So number 1, to satisfy himself that the meeting, has been properly convened. To satisfy himself that the meeting has been properly convened. To satisfy himself that the meeting has been properly convened. To satisfy himself that the meeting has been properly convened. To satisfy himself that the meeting has been properly convened. Properly convened as per the articles or the statute, as per the articles or statutes, as per the articles or statutes, as per the articles or statutes. as per the articles or statutes. Then number 2, to ensure the proceedings are conducted in accordance with the rules governing the meeting. To ensure the proceedings are conducted, to ensure the proceedings are conducted, to ensure the proceedings are conducted, to ensure the proceedings are conducted in accordance with the rules, governing the meeting, in accordance with the rules governing the meeting, to ensure the proceedings are conducted in accordance with the rules governing the meeting. The next one, to preserve order in the meeting, 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 to preserve order in the meeting. To preserve order in the meeting. The next one, to ensure the business, being dealt out, to ensure the business being dealt out, to ensure the business being dealt out is as per the agenda. To ensure the business being dealt out is as per the agenda of the meeting, 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 is as per the agenda of the meeting. Then the next one, duty to allow reasonable discussion, duty to allow reasonable discussion in the meeting, 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 duty to allow reasonable discussion in the meeting. Duty to allow reasonable discussion in the meeting. So the powers, you can state the powers of the chairman, the powers of the chairman, the powers of the chairman. So number 1, to decide on points of order as they arise, to decide on points of order as they arise, to decide on points of order as they arise, to decide on points of order as they arise, and give his rulings, to decide on points of order as they arise and give his rulings, to decide on points of order as they arise and give his rulings. decide on points of order as they arise and give his rulings. Number 2, to cast his votes in good faith. Number 2, to cast his vote in good faith when there is equality of votes. In this case, is like the tiebreaker. To cast his vote in good faith. To cast his vote in good faith. To cast his vote in good faith. Where there is equality of votes. To cast his vote in good faith, where there is equality in votes. So you can see he has the power to be the tiebreaker. The power to be the tiebreaker. To cast his vote in good faith. Cast his vote in good faith, where there is equality. The next one. What does number 2 actually mean? You know, as the chairman, for example, if this particular meeting is actually being attended by 10 persons and the chairman is the 11th person, so you are going to vote and decide on a particular matter. The chairman is not voting. So the 10 persons are the ones who are supposed to vote. So they happen to vote, and of course 5 are for this particular side and 5 are for this other side. So there is no winner. So you can see now who has the power there now. The chairman is the one now who will choose either to vote for this other side or not. That is our power. So he can basically vote, and this other side has 6 persons, and that side will actually win. So you can see that is our power that he has to be the tiebreaker in case there is a tie. That is what we mean by that point. I hope that is clear. To order remand or eviction of disorderly persons. 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 The next one, to order removal of a person who has no right to attend the meeting. To order removal of a person who has no right to attend the meeting. To order removal of a person who has no right to attend the meeting. To order removal of a person who has no right to attend the meeting. The last one, the power to adjourn the meeting. The power to adjourn the meeting. Adjourn simply means to postpone. The power to adjourn the meeting. The power to adjourn the meeting. The power to adjourn the meeting, which is derived from the meeting itself. Which is derived from the meeting itself. The power to adjourn the meeting, which is derived from the meeting itself. Which is derived from the meeting itself. The power to adjourn the meeting, which is derived from the meeting itself, i.e., consent of the members present. Consents, by consent, you can say by, i.e., what you mean by that, i.e., by consent or approval of the members present. By consent or approval of the members present. So of course, he'll make that declaration, but it has basically also to be supported by the members present so that it can actually be a proper adjournment. So you'll make the declaration. Basically, since there's no quorum, this particular meeting will actually be held in maybe 2 weeks' time, so that we can actually be able to have quorum. And of course, all the other members will actually be able to support, those members present will actually be able to support such kind of an adjournment, So those are the duties and powers of the chairman, So I think we'll end there the class. So we'll pick up from there next time, wind up on this particular topic, just a few things remaining, and we shall start the topic of directors in our next class.
Mwalimu,
Yes.
before we go, as we were looking for that question of chairperson.
That question of?
As we were perusing, looking for that question of the chairperson.
Yes.
I came across this question of November 2016, question 5C.
It talks about what?
State 4 items of agenda at an annual general meeting of a company.
Oh, that's what we haven't covered. We look at it under the types of meetings. But of course, the items of agenda, maybe I can just state them. So for the sake of for your benefit, we look at it under types of meetings, because other types of meetings, we look at AGM, general meeting, creditors meeting, board of directors meeting, then a class meeting. But mostly we normally dwell much on a general meeting and an AGM. So the key items of agenda at an annual general meeting of a company or an AGM, it is normally number one, approval of the annual dividends to be paid to the members. Approval of the annual dividends to be paid to the members. That is one item of agenda that must be there. Number two, approval of the annual accounts, or can simply be able to say the audited accounts of the company. That is number two. So you've said approval of the annual dividends to be paid to the members. Number two, approval of the annual books of accounts, or basically audited books of accounts of the company. That one should actually happen at an AGM of a company. Number three, appointments and removal of directors of a company. That is will actually also happen at an AGM of a company. Appointments and removal of directors of a company. Number four, appointments and removal of auditors of a company. Then, of course, number five, there can be any other agenda that they think is actually very important to be discussed at the AGM. But those ones, it is a must they happen at the AGM. Like, for example, you normally hear that they have paid dividends after an AGM. So they normally wait. What will happen is that the directors will just propose, for example, this year are going to pay 6 shillings per share as dividends. But of course, it will only be paid after the AGM once the approval has actually happened. So they have already approved this, what we are going to pay as dividends as owners or shareholders of the company. That's when now after the AGM, that's when now the company goes ahead to basically pay the dividends now. So we've said items of agenda number one, approval of the proposed annual dividends to be paid to the members. Number two, approval of the audited books of accounts of the company. Number three, appointment and removal of directors of a company. Number four, appointments and removal of auditors of a company. Then number five, any other item of agenda that is actually very important to be discussed at the AGM. I hope I'm clear on that. Are we okay on that particular question? Although we'll look at it later on before we finish this particular topic.
It's okay.
It's okay.
Yeah.
So I think we can end there. We'll meet next time, unless there's a burning question. So I think I've shared notes for topic 7 and 8. You must have realized that they are just this evening. So we'll wind up with topic 7 and of course start topic 8 in our next class. So we are going to move a bit faster. So don't afford to miss a class. Try your best. Even if you don't have time, try your best to ensure you attend the classes, because if you miss, then now when we start doing the revision or when the exam is almost near, there'll be some form of fear. So, and of course, you don't have to fear. So these are very easy paper. And of course, I can assure you, if you are well prepared in company law, and this is the experience I've had, something surprisingly, in company law, when you're in the exam room, so you'll see some of the students who are sitting for the exam, after like 1 hour or 1.5 hours, they are leaving the exam room. So they have finished the paper. So I can assure you, if you are one of them who prepared so well, you'll actually be able to finish the paper very early, and it's actually a very easy paper. It's not a hard paper. You just have to basically ensure you have some form of confidence. Then, of course, prepare so well. This one is not like, there are some other exam papers. You leave the exam room, then you start saying that financial reporting, manze ile swali ya consolidation. Hii tumeachia tu mwalimu, tumeachia tu Mungu. Mwalimu hii tumeachia tu Mungu. So for company law, if you are prepared so well, you leave the exam room. I can assure you, you leave the exam room knowing this one I'm going to pass. If you prepare so well, you leave the exam room knowing this paper I'm going to pass. And this experience I've had with my previous students. So just keep on preparing so well. Attend all the classes. This is what I normally encourage my students. Attend all the classes if you can. Unless it's something beyond your control, then you can avoid to attend. Some students assume that these theory papers, they are not so hard. Once the teachers just shared the notes, then that is okay. But I really insist, I normally encourage my students to attend the classes. As I've told you previously, just come and sit there. Listen to this teacher. What is this teacher saying? Just listen to this teacher. Listen to him very carefully. Then just take your short notes. Once you take your short notes, come for the block revision classes. Then I can assure you, you'll just leave the exam room very, very happy. So I wish you a good night. We'll meet next time. So that is actually on Sunday. So as I've told you previously, if you are doing your private revision and you come across a difficult question, the teacher is just a phone call away. The teacher is just WhatsApp away. You can WhatsApp the teacher. You can post on the group. That's why we have that platform. You can post a question there. So I'm not that kind of teachers who are on a blue tick. If I see this is my students and I know who anamuona pale, I normally see this is D or this is actually Victor. Actually, I will respond. And if you actually give a call, I'll actually also guide you on how you're supposed to handle this particular paper, because the wish of the teacher is for you to pass the exam and actually move to the next level, such that we might meet in another forum, and you'll actually just be very happy that you actually passed the paper, and I'll be glad that you actually moved to the next level, and now you are CPA. Now basically you are now doing other things, or maybe you've started another course like that. So we'll meet next time. You can have a good night.
Same.